The broadcast is now starting. All attendees are in listen-only mode.
Hello, and welcome to today's webinar, Employment Law Issues in the Era of COVID, presented by our sponsor, Heffernan. We're so happy you can join us. My name is Deb Beto, and I will be your moderator today and be monitoring questions you may have during the session. Before we open up the session, let's review a couple of key items. All of the webinar materials we discuss can be found at the URL currently showing on your screen. I will be sharing this URL in a follow-up email, so don't feel like you need to write it down right now. If you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. If you have audio difficulties or a telephone line goes dead during the call, hang up and call back again to the same number. If all lines go dead, watch the on-screen chat box for an alternative call-in number. Please feel free to ask questions or provide feedback by using the chat box or questions box during the webinar. If you are using a tablet, you may need to tap on the screen for the options bar to appear, and then you can select the appropriate option. We may not respond immediately, but we will try to work your questions or feedback into the presentation. If we can't get to your comment or question during the session, we will be online afterwards to respond, or we may follow up in an email if we run completely out of time. You may also email us at moderator@aspenrmg.com for up to 48 hours after the webinar. This will be a 1-hour presentation. Questions and comments are very much encouraged throughout, and the presenter will be answering questions as they come in and also at the end. And lastly, we have a number of webinars upcoming covering a variety of topics, including those listed at the Heffernan webinar website. In addition, we offer the mandatory Preventing Harassment training in English 3 times a year. With that, let's begin today's webinar, Employment Law Issues in the Era of COVID, presented by Sarju Naran. Sarju Naran is a zealous advocate for his clients and approaches litigation with creativity and strategy. Chair of Hoag Fenton's Employment Law Group, Sarju's experience spans from representing middle market and family-owned closely held businesses to large multinational companies. He regularly litigates and provides advice and counsel to companies on wage and hour issues, trade secret misappropriation, employee mobility, wrongful termination, performance management, and leaves of absence. Welcome, Sarju.
Thank you, and thank you, Heffernan, for having me. Thank you all for joining. We're going to be talking about employment law issues in the current era that we're in. And as I'm sure you can appreciate, if you are an employee of a business or managing a business, the landscape keeps changing. And what we've also learned, unfortunately, is that we're going to be in this situation for quite a while. So it's important for us to understand where the risks are and calibrate now that we've got some time to do it. I know at the beginning of this pandemic, we were all sort of rushed to close our businesses and put into place several restrictions that we may not have been ready for. And so we just kind of needed to do it sight unseen without understanding what the ramifications were. But now that we know that we're going to be in this for a while, I think it's important to be mindful of some of the employment law risks that are out there and prepare to the best to our ability, to be able to avoid those sorts of risks. So we're going to be talking about employment law issues stemming from a few different types of work environments with the employment relationship, including those pertaining to remote employees, those that are working offsite, presumably at home or some other offsite location outside of your controlled work site or an area that's designated by you, and also employees that are working on site. So as we go, we do have a few poll questions because we do want to know who you all are and what your thoughts are on some of these issues and how you guys are navigating the situation. So if we can start with poll question number 1, and then we can spend a couple minutes talking about that issue.
Okay, so poll question number 1. Do you currently have more than a handful of employees working on site? This is a yes or no. And I typically like to see that we've got a good majority of the people voting before we read our answers. And I will also be using this time period during the polling questions to ask any questions that you might have had about the materials presented. So make sure that you participate so that we don't hold the rest of the group up, and then we will ask questions. So Sarju, in this question, we have 63% say yes and 37% say no.
All right, well, that's great. I think it's interesting to know. We don't want to make assumptions about what all work sites look like, and every industry is going to be a little bit different. And as I'm sure everybody recalls, back in March, we were all asked to shut down at least temporarily, and then the restrictions started easing up a little bit. Then there was the question of, well, who's an essential business? What's an essential employee? Am I allowed to have these people come back? So let's spend some time focused on this first area of folks that are working remotely. It sounds like plenty of you, even if it's not a majority, have folks that are working off-site, whether it's all of them or some of them. So what are the issues that we should be thinking about in that environment? Deb, can you read off poll question number 2, please?
Got it, Sarju. So our second polling question, do you expect that you will maintain a remote workforce after the pandemic ends? We're getting a lot of people voting early, so that's good. We like the participation. And in this case, we have 15% say yes, 36% say no, 20% may have some employees continue to work remotely full-time, 27% may move to a hybrid model, work on-site as needed or on a rotation or some other method, and 4% say other.
Okay, great. Thanks for that feedback. I get it. A lot of companies that prior to the pandemic were not acclimated to having employees work remotely, or not that many employees at least, are now seeing a couple of things. One, employees appreciate the flexibility. And 2, employees can, by and large, be productive. That doesn't necessarily mean that all employees are productive, and we have to deal with those issues as they arise. So it's good to be thinking about not just our current situation and what we need to be doing now, but thinking long term. And one of the things that we often find outside of the pandemic environment is that employers usually don't want to have their non-exempt employees, their hourly employees, working remotely. Exempt employees, it's a little easier, right? They're not subject to overtime requirements. They're not subject to meal and rest break requirements. They are paid for their work, not for their time. As a result, they're able to structure their day however they see fit, as long as it's consistent with them meeting their obligations. With hourly employees, it's a little bit trickier because we do have meal and rest break and overtime requirements. So what does that look like for folks that are working remotely? They still need to keep track of their time, right? It's super important. They're clocking in when they start their workday. They clock out when they take a break for lunch. They clock back in after they return from lunch, and then they clock back out at the end of the day. If your employees are not currently doing that while they're working remotely, you're leaving yourself open for wage and hour claims, for missed breaks, late breaks, short breaks, unpaid overtime, off the clock work. So it's super important that while you've got employees working remotely, they're not becoming more lax in terms of their record keeping and their timekeeping. It's harder when they're not in the workplace because, for one, they don't have the type of oversight that they normally do. And the managers aren't there to say, hey, it's time for you to go take a break, or it looks like you've gone past your 8 hours. That's difficult to do in a workplace as well. And I know a lot of folks are out in the field. They're not necessarily sitting in an office environment. But it is a little easier to do when people are on site. One of the other challenges right now when you've got folks that are working remotely is that they may be structuring their day a lot differently than they normally do. They may have childcare responsibilities. They may have other personal things going on, that they're errands and whatnot that they're attending to throughout the day. So it may not look like a 4-hour block and then a lunch and then another 4-hour block. It may be that they're spending half an hour here, then they clock out and they're attending to some personal business, and then they come back. And that's okay. There's nothing per se wrong about that. But what's important is that you're letting your employees know that they have an obligation to accurately reflect their time in their records. So if they're going to be clocking in and out like that throughout the day, they just need to clock every time they do that. Ultimately, what we care is that they're putting in the hours that are expected of them, and that they're not running over and spending more time and going into overtime unless that time is approved. So something to just be aware of, because as folks are working remotely, that's not something we typically think about for our hourly employees. Can you pull up poll question number 3, Deb?
Got it. So, poll question number 3. Are you reimbursing employees for expenses associated with working from home? All right, we have good participation again. I'm going to wait until we have about 75 to 80% of the people voting, which won't take long with this group. You guys are fast on the draw today. Okay, Sarju, 22% say no, 35% say no, we provide employees with everything to work remotely. 13% say only if employees ask. 11% say we pay a fixed amount each month for certain items. And 21% says, yes, we have a policy that lists what expenses we will cover.
Excellent. Okay, yeah, we do have a mixed bag of results there, which is not surprising. You know, the key thing here is to be thinking about this issue. Expense reimbursement is something that you may not be dealing with as much when folks are working on site, especially your workforce that doesn't need to leave to go out into the field. They don't travel for work. They don't have to go visit clients or customers or vendors. Their office is their work site. You do provide them everything that they need in that environment, and there's rarely, if ever, a need for them to incur any business expenses. And I'm sure that many of you are also familiar with employees that are incurring expenses, whether it's client entertainment, whether it's travel, what have you. It may be that they need tools to be able to work remotely as well as working on site. So what the law says in California is that you're required to reimburse employees for all necessary expenses that they incur in the course of carrying out their duties. So what does that mean? It's not specifically defined as it relates to every item that an employee may need, but there is good case law, at least on the issue of cell phones. And if you have employees that are required to use a personal cell phone for business purposes, there's a case that came out a few years ago where the court said that even though the employee may be paying for some sort of unlimited plan, they don't get charged by the minute, for instance. They may get charged for data, but not by the minute for phone usage. Just because they're not paying any more to use their phone for business purposes doesn't mean that the company gets to pass its operating costs onto its employees. And there's an obligation on the part of the employer to reimburse at least a reasonable percentage of that cell phone bill. Okay, so what does that mean? If you've got an employee who is not being provided with a company phone, and again, that could be a company phone in the office, a landline, or while they're working remotely because they're not allowed to work in the office, they're not being provided with a phone by the company, whether it's a cell phone or a landline at home, well then the employee presumably still needs to be able to communicate with their employer, with clients, whoever it may be. And if that's an expectation that they need to be able to communicate, that means they're needing to use their personal device in order to carry out that job function. In that situation, even if the employee is not paying any more money to use it for business purposes than they are for personal purposes, the company's going to have to come up with a reasonable amount that they're reimbursing that employee. You can ask employees to submit their cell phone bills so that that's sort of the trigger for you to reimburse them. And it doesn't have to be for the full amount of the bill. The amount, of course, the law doesn't define it. It's a reasonable percentage. So you do need to make a determination as to what that means and what you think is fair and appropriate. But what you can't do is say, well, I'm not paying for that because it doesn't cost you any more, because that is a tool that's required of them in order to carry out their function. So the cell phones are actually relatively easy when we're having this discussion about what needs to be reimbursed. When you've got folks working remotely, again, the question used to be, it's not as relevant during the pandemic, but the question used to be, and it will be again, Why is the person working from home? Is it their choice or is it the employer's choice? If it's the employee's choice and they're saying, I know you've got an office for me, but I prefer to work from home. It cuts down my commute. I can be more productive. Or maybe it's a I'm going to work from home part of the time situation. And you're accommodating that. Well, that's not a situation where you're going to have to reimburse them for their office expenses, because you actually do provide them with all the tools they need to be able to work on site. They're choosing to work remotely. Right now, that's not the case. Presumably, anyway, most employees are working remotely, not because they don't feel safe coming to the office, although that might be another factor, but it's because you're unable to return them to work. You don't feel safe, there are government restrictions, what have you. And that's the question. If it's not for the employee's benefit that they're working from home and it's not at their request, then the employer does have that obligation. So if you're working remotely and you need to be connected to the server for work to access documents and whatnot, well, then presumably you're going to need an internet connection. And that's another thing that by logical extension, if you're looking at the case on cell phones, the same logic would apply to internet connection. So I would say, to bare minimum, we're talking about cell phone service, we're talking about internet service. I know that some of you answer the survey and said that you provide employees with everything they need. And a lot of companies will do that, what I sort of call an office in a box, right? We're going to give you your phone, we're going to give you a computer, we're going to give you a printer, we might give you a modem and a router. If you're not providing those tools and the employee is using their own, those are all things that presumably you are going to need to reimburse that employee for. And it doesn't necessarily mean that you have to pay for the full cost of it if it's being used for both personal purposes as well as for business. But those are certainly line items that you need to be thinking about reimbursing. And if employees are seeking that reimbursement, you need to pay for them. Some companies are more proactive than others, and I heard this in the survey as well. Some people have a policy and say, yeah, we've got a set amount that we pay for each one of these items. Others don't. Others wait for employees to submit the receipt or make a request for reimbursement. We have not yet seen that many claims arising out of this issue, but we're expecting them to come because we've got so many people working from home and so few employees that are paying. Now, the items that I identified, computer, phone, internet, modem, router, cell phone bill, internet bill, those are relatively easy. The tougher discussion is, do you need to pay for other items that allow an employee to work from home, such as their desk, their chair? Even that, I think, is relatively easy. But then you get to this next category of, well, what about the fact that you're not providing them with an office? So they need to dedicate a space in their home. Does that mean you got to pay for part of the rent for their home? What about the increased utilities that they're incurring by virtue of the fact that they have to work from home? Water, electricity, toilet paper, soap, right? These are all items that are arguably reimbursable. And so there is no clear ruling on those issues yet, but that's one of the areas that I've got some concern. I think we may be heading into territory where employees are pursuing those sorts of claims against employers, seeking reimbursement from items that allow the employee to work from home and are costs that they weren't previously incurring. And keep in mind, not every employee is going to have a suitable space in their home to be able to work remotely. So they may need to make arrangements and make modifications. And by virtue of doing that, it may be that that space can't really be used for anything else. So it's fair when you look at it from that perspective. But again, the courts have not yet weighed in on that issue. But it's a little bit scary, but at least at a minimum, I would say make sure that you've got a policy that does provide for reimbursement for some of the basic items that we discussed. And I would recommend talking to counsel about whether you proactively also reimburse for some of these other items. So another issue with remote employees is disciplining employees or terminating employees based on performance. Of course, most employees are at will. That means that they can be terminated or they can leave for any reason, with or without notice, with or without any good cause. And that's generally the case, but of course, as I'm sure you know, there are many, many exceptions to the at-will rule as it relates to harassment, discrimination, retaliation. And when we're having that discussion, it's very, very important that we're being consistent. And when we've got employees that are working remotely, it's very quick for us to judge whether someone is being as productive as we think they should be, or as productive as they are in the office. And there may be multiple reasons for why an employee can't be as productive from home. Some of them may be socioeconomic, right? So if they don't have reliable internet connectivity, for instance, or they don't have a suitable workplace, which is something I was just referring to a couple minutes ago. those are things that you may want to provide some allowance for rather than judging too harshly. Of course, letting somebody go based on socioeconomic factors is not unlawful, but it's going to leave a bad taste in their mouth. And of course, there is a case to be made by folks that really what you were targeting before was not my socioeconomic status, and it really wasn't based on legitimate performance issues. It's because I belong to this protected class. I am an ethnic minority. I live in an area that's predominantly of that same ethnic minority, that's of lower socioeconomic class, just by way of example. So we got to be mindful, right? Are we being tolerant, or do we understand what the effects would be of us disciplining employees in this situation? Are we trying to help employees adapt to this new environment and accommodate their situation, or are we judging them too harshly? So the last one I'll mention under the category of remote employees is employer claims, because employees aren't the only ones that might have grounds for legal claims in our current environment. Again, when you've got folks that are working in the office under greater oversight, they tend to behave. What you might find with employees working remotely is that they're accessing confidential information from your database, from your servers. They may be downloading that information onto personal hard drives or thumb drives and then using them so that they can then go compete with you with another employer. We've seen a couple of things like this thus far. In my experience, a couple of cases along those lines. It may be that employees, because they don't have that kind of oversight, they are accessing data. They're also reaching out to their colleagues to try to solicit other employees away so that they can all leave together. So that's the type of thing that it's hard to detect in the moment, but there are ways. If you start seeing indications that your employees are going sideways on you, that might be a good trigger for you to talk to your IT department to take a look at what's going on in their email traffic, what's going on with their file access. Most folks that are logging in remotely have to use login credentials in order to do that. So you should be able to track, well, what sorts of data, what sorts of documents are they accessing? Are they downloading them? What are they doing with them? Is that stuff that's appropriate for them to be looking at in the normal course of their job? Or does that seem to be a little bit odd? Are there emails to and from to other employees about leaving the company with competitors? Is the employee sending company emails to their own personal address so that they can have them for personal use for future purposes? So all things to be aware of. And if you're seeing those sorts of clues, it's a good time to call counsel, of course, but it's also a good time for you to perk up, get your IT involved, and see if you can determine whether employees are engaging in activities that would be unfairly competitive against your company. So with that, I'm going to move on from remote employees and move on to our next section on on-site employees. And so to get us kicked off there, can you please read off poll question number 4, Deb?
Yes. If your employees are mostly remote, what is keeping you from returning them to work? And I have a couple of questions that came in. Do we need to collect cell phone bills even if we're giving them a flat rate reimbursement?
I think for IRS purposes, I would say yes, because even though it's a flat rate that you're paying them, you still need to be able to demonstrate that that was a business expense. So if you're simply giving employees, I think this is more of a tax issue, frankly, than an employment issue. But for your own record-keeping purposes, that's a good idea. The other thing I'll say about that, and this is a little bit nuanced, but what the law says is that you have to reimburse employees for their necessary and reasonable expenses. For a cell phone, you can come up with a flat amount. That's pretty common, actually. Most employers will do that. But it's a good idea to also tell employees that if they believe that flat amount is insufficient to reimburse them for their business use of their personal phone, they should provide you with documentation to support why you would be paying them a higher amount so that you can review it and approve it if appropriate and pay them that higher amount. Okay. You can't do that unless you actually have the cell phone bills. So I think it's a good business practice with respect to everything other than mileage to have the documentation to back it up.
Okay, and a quick question. Are these laws only for California-based employees or other states too?
It's a great question. I actually just had a conversation with a client about that this morning. I am speaking specifically to California. Every state is different. Every state has its own rules. As I'm sure you can appreciate, California's rules are typically a lot more restrictive and more employee friendly than many other states. So I can't speak to what other states are doing. There are many states that don't have any expense reimbursement rules per se. All they do is they follow the federal guidance under the Fair Labor Standards Act. But even under the Fair Labor Standards Act, there is an expectation that you're going to be reimbursing employees for their business expenses. So that it's not like there's a state in the union that says you don't have to reimburse employees. The question is, what do you have to reimburse them for? And for that, you would need state-specific guidance looking at court cases and legislation in each individual state. So yeah, the guidance that I'm providing is specific to California.
All right. So back to our polling question, we have 39% that say our employees are concerned about safety. 26% say government restrictions. 5% say cost savings for company to have them working remotely. And 30% say our company is concerned about not being safe enough.
Would you do me a favor and read back the question and the answers one more time, Deb?
Sure. If your employees are mostly remote, what is keeping you from bringing them back to work? So 38% were concerned about employee safety, 27% government restrictions, 5% cost savings, and 30% our company is concerned about not being able to be safe enough.
Okay. All right, great. Thank you for that. I appreciate it.
Sure.
Yeah, I'm not surprised that there aren't a lot of employers that think this represents a cost savings. It does in some respects, obviously, especially in the category of like client entertainment. People aren't gathering. They're not going out to events and conferences. But that has less to do with them working remote and more to do with the fact that everybody is sort of in the situation together. So safety seems to be really the biggest factor, whether it's employee concerns or employer concerns or government concerns. So a few issues to be thinking about as it relates to bringing employees back to the workplace. Can you do it? Should you do it? What does it mean if you do it? One, privacy issues. So we did get some good guidance early on in this pandemic. Typically, you can't take temperature checks of employees, right? Under normal circumstances, that would be considered a medical exam, which would be in violation of the Americans with Disabilities Act. However, because we're in a pandemic, the EEOC, the Equal Employment Opportunity Commission, has issued guidance, and this is similar to what they said back when H1N1 was an issue about 10 years ago, that based on the widespread virus and how contagious this virus is, this is a situation where we're willing to relax the rules somewhat and allow employers to take temperature checks of employees. So despite the fact that there are privacy rules and issues that you still need to be mindful of with employees, you can take their temperature. What I would recommend is you don't record that temperature and put it in writing. But if you are going to put it in writing, I would have a separate document for each employee and store that information confidentially, because otherwise, if you've got like a sign-in sheet, for instance, when employees show up, every employee that comes in is going to be able to see every prior employee's temperature when it was checked earlier that day. That could be a breach of confidentiality, a breach of privacy. So it is allowed, but keep in mind that it doesn't completely invalidate an employee's right to privacy. Another issue, well, actually, let me talk about this real quick. If you have an employee that's on site that does test positive for COVID, that's another area that I get a lot of inquiries about. Obviously, it raises a lot of concerns for you as an employer, and you want to do everything that you can to protect your other employees. So the natural thing is to want to ask, hey, have you been in contact with so-and-so in the last 48 hours? The law does not allow you to do that. And that's where there are some limitations on privacy rights, right? Or excuse me, on the loosening of privacy rights. Employees have a right to anonymity as it relates to their medical conditions. So while you can certainly ask the employee who tested positive, please identify everyone that you've come into close contact with over the last 2 days, so that we can appropriately notify those folks. Beyond that, you just have to kind of do a little bit of investigation on your own, because you're not allowed to tell anybody who it is that tested positive. So you are a little bit hamstrung in that regard. And I know that can be frustrating, but that is the law of the land at the moment. So another area as it relates to issues such as temperature checks, right? We've got all this social distancing protocol now, right? We're saying, hey, when you come in, you need to get your temperature checked, you need to wash your hands, you need to sign in, you need to sign out. Okay, well, that's fine. Keep in mind that all of those tasks are employer required tasks. It means that the employee is under your control and they're doing that at your direction. And what that means from a wage and hour standpoint is that that's going to be considered compensable time. Right? So whereas an employee may normally show up and just go to their desk and then they log in, and that's when their day starts, keep in mind that if they're taking another 5-10 minutes because they have to get their temperature checked, they need to sign in sheet, they're having to do that again when they sign out, that's all time that's on the company clock. So that's another area where we expect to start seeing claims as we move forward, because employees, unfortunately right now, a lot of employers are finding themselves in a situation where they have to make tough employee decisions. And I'll talk about that in a little bit. But whenever that happens, there is always going to be a handful of employees that are unhappy about the decision that they're being let go. So they'll go talk to an attorney. And oftentimes the attorney will tell them, look, there's nothing wrong with your employer letting you go. There's nothing discriminatory about it. But let's talk about some wage and hour issues. Let's see if they were compliant in these other regards. And that's when they're going to have discussions about things like compensable time. Did they compensate you for that extra 5 to 10 minutes every day that you had to get your temperature checked and sign in and sign out? Did they reimburse you for all of your expenses? Were they paying you for your missed meal breaks and your rest breaks? How do they know that you took your meal breaks? What about overtime? Were they communicating with you after hours? Because everything's sort of loosey-goosey now. Even though you're only supposed to be working from 8 to 5, they were texting you at 7 p.m. and expecting a response. Well, those are all sorts of things that could give rise to a wage and hour claim. So another big issue with employees being on site is this challenge of accommodating employees with disabilities that might render them vulnerable to COVID-19. So if you've got employees that you need to have at the work site, you're an essential business, they're an essential employee, there's nothing restricting them from coming in terms of legal restrictions, in terms of government restrictions, I should say. But the employee tells you that, look, I don't feel safe being here. I don't want to be here. There's a question to ask there. What is it that's causing them to feel unsafe? Is it just general concern? If that's the case, you can require them to come in. They're not allowed to make the decision that I just don't feel safe, so I'm not going to, unless they have a credible belief that the workplace is not being kept safe enough. Under OSHA, there is a limitation. You can't require employees to come to a hazardous workplace. So it's on the employer to make sure that they're doing what they need to do to maintain a safe work environment. But if that's not the issue, if the employee is saying, look, it just gives me anxiety, well, that's a buzzword. You should be paying attention to what the employee is telling you, right? So if they say anxiety, that's a medical condition. That constitutes a potential disability. So you would need to have a discussion with that employee at that point. Is this something that we can accommodate or not? This employee is telling me that they're disabled, right? That's really what they're saying to you. And just like in any other situation, you want to have an interactive discussion with them about what accommodations they're seeking and whether they're reasonable or not. And you can also ask them for a medical certification to support their request to not be able to come into the office. And of course, for many employees, that may mean that they can't work at all. If they're not on site, they can't work. So is that reasonable or not? You kind of just need to go through that process and determine if it really is something that a doctor would certify as being a disability. And then, of course, there are other disabilities that are a little more common and easier to perceive. And if an employee is saying that, look, I've got asthma or I've got some other medical issue that renders me vulnerable, under the ADA, under FEHA, those are the types of things that employers are going to want to accommodate as long as they can do so reasonably. So we don't want to jump to the conclusion that, look, we need you here, so you have to be here. On the flip side, there are concerns that, and we've seen some of this with employers making decisions that, hey, we need to return our employees to the workplace, but we don't want an outbreak and we want to keep our employees safe. So we're going to pick and choose who comes back. We're not going to allow anybody to come back if we're aware that they're elderly or that they have a medical issue. Well, while that sounds noble, it sounds like you've got your heart in the right place. The problem with that is that it's discriminatory. Some of these employees may want to return to the workplace, and yet you're making a decision for them that they're unfit to return. So even if you're trying to protect an older workforce because they're more at risk for COVID, or you're trying to protect people that have health issues, it's really their determination. And of course, they're doctors as well. They should be doing what's safe for them. But you as an employer, and there's case law prior to the pandemic that's similar to this, you as an employer don't get to play doctor and make that decision, right? The prior precedent that we have along these same lines is as it pertains to employers that make decisions on behalf of pregnant employees that, we can't have you doing that work anymore because you're pregnant, it's not safe for you. Well, we as the employer don't get to make that determination. If the employee says, I can't do this work, or the doctor says the employee can't do that work, then you've got an obligation to accommodate. But short of that, we don't make that call for them. Are there any other questions at this point, Deb, before we move on to poll question number 5?
I think we are good for now. We did have an I-9 question that came up, and I'm not sure if I'm asking the question the right way, but for remote employees, how do you make sure you're collecting the correct documentation for somebody hired in another city or state?
It's a good question, and I'm to be honest, I'm a little bit fuzzy on the details of this, but I know the rules have been relaxed during the pandemic because normally you're required to have a live witness watch the person sign, and I know that there are ways to avoid doing that right now, and it may be that it needs to be done via video call, but it can be done remotely. But unfortunately I don't have the rules on that clearly in mind right now.
Okay.
There is clear guidance on it though, and I recall this coming up a few months ago because unfortunately this is going on long enough where we are hiring employees during this situation, so we need to figure out how to onboard them properly.
Right. Okay, that was it.
Okay. Can you read off poll question 5 for me? Thanks.
Sure. So, if permitted, do you feel your workplace is safe enough to return all employees? And this is yes or no. And again, if permitted, we didn't have enough space to write it in the full intention of the question, but if regulations permit you to bring your employees back, do you feel your workplace is safe enough to return all employees? So, or are you opening yourself up to more litigation? So we're getting a good number of people responding, and good, 72% say yes and 27% say no.
Well, that's great. Of course, not so much for the 22%, but it's great to hear that many employers feel comfortable that they're doing what they need. It's very, very tough right now. This is an invisible virus, right? How can we ever know what is safe enough? We're doing the best that we can, but of course there is protocol that's being issued by the CDC, by OSHA, by local governments, by the state, by counties, by cities in some instances. So as long as you're doing those things, you're doing what you need to do to minimize risk, and you can have your employees on site. I think that's wonderful. Of course, the nightmare scenario is that you do all those things and somebody tests positive anyway, and that you have an outbreak in the workforce. And those are all concerns that I deal with on a pretty regular basis. And there's a lot of rules around that issue. So as we talked about a few minutes ago, some of the concerns with respect to returning employees to work is that employees don't want to. And as I mentioned, just to sort of recap, OSHA only allows employees to say, I'm not returning if their concern and their fear is credible. And one of the ways that it can be deemed credible is that there are other employees that support that belief as well. And that could be considered protected concerted activity, which is something that you've probably heard about under the National Labor Relations Act. All employees are entitled to engage in protected concerted activity, and you can't retaliate against them for doing so. So if you've got a group of employees that say, look, we just don't think the workplace is safe enough, it may be that they're wrong, maybe that they're right. If they're right, then under OSHA as well, you can't require them to come on site. If they're wrong, it's a touchy issue because you can legitimately require that they all come into the office. And if they don't, you can legitimately take disciplinary action against them, up to and including termination. But there may be risk associated with that because this group could say, well, we were engaged in protected concerted activity. What you were disciplining us for or terminating us for is not our refusal to come on site, but it was because we were banding together. So that could be a concern. You know, the only real way to head that off is to do everything that you really can, that you reasonably can, to try to ensure employees that you have a safe work site for them. Identify what your protocol is, which in many counties you have a requirement to do that anyway, right? You probably all know there's the COVID-19 prepared signs that you need to post at the front of your facility. In an office environment, same thing. You may not have members of the public coming in, but that sign is there for your employees. Many counties also require social distancing protocol that sets forth all the things that you're doing. But don't think of that as a task, that checklist. Think of it as a way to communicate to your employees and assure them that you're doing what you can to keep them safe. That's what you need to sort of relieve that concern and anxiety, which is, you know, clearly it's understandable because we see the spread even when people are doing all the right things, even when people are wearing masks and distancing. Sometimes the virus spreads anyway. And it's often because of not anything that you're doing wrong in the workplace, but because people are engaging in their everyday lives outside of the workplace. Just something that you can't really do a whole lot about, which is another area of concern. Can you terminate or discipline employees or take any sort of employment action on the basis of employees engaging in off-duty conduct? What the law says about this generally is that if employees are engaging in lawful activity, you can't retaliate against them for doing so. So for instance, if engaging in a protest, right? We saw a lot of protests over the summer. They're ongoing throughout the country. Is that something you can discipline an employee for? Well, for the act of engaging, of going to a protest, no. You can't discipline them for that. On the other hand, if you've got folks that are traveling, and I get these sorts of inquiries all the time. If you got employees that notify you, hey, I'm traveling out of state, I'm on an airplane going here, I went to this event, I went to a concert, I went to a rally. Employers are obviously concerned about, okay, well, that's fine, that's your conduct, you're free to do all those things, but we can't have you in the workplace then because you could potentially be exposing other people. Well, again, in this situation, employers actually do have the ability, even though it's normally considered a medical exam, you could require employees to take a COVID test. You can even ask them to stay home for a certain period of time. Could that be viewed as retaliatory? Yes. What I would say is that it's a risk worth taking because your motive presumably is not to retaliate, but rather to maintain a safe workplace. And with that being a legitimate overriding reason, I'm in favor of employers making those decisions. Excuse me. Terminating people because of COVID concerns. So if you've got employees that are engaging in what you believe to be reckless behavior, can you let them go? Again, employment is at will. So the answer is objectively yes. But again, the question comes back to, is the employee going to accept that that's the real reason why you let them go? And what I've found in my years of practice is that employees will find a way to pursue a claim. It may not be the one that they think they're entitled to money for, but they'll come up with something. And there's lots of lawyers out there that are willing to have that conversation, as I mentioned earlier. It's a typical scenario. An employee goes into the attorney's office and says, I think I've been wrongfully terminated. The attorney asks them about the situation and tells them, no, but let's talk about what else is going on. Let's talk about the wage and hour practices. So while you're certainly, you have the discretion to take disciplinary action against employees that you believe are posing a health and safety risk to themselves and to other employees, there is the risk that by taking that action, you may land yourself in the middle of a legal claim. Give me 1 second here. Let me take a look at my notes. All right, so if you have employees that are coming to the office, to your workplace, either with COVID symptoms or with a positive COVID test, what can you do? What should you do? What are you allowed to do? Obviously, that's a scary situation. And luckily, the government does support an employer's ability to send an employee home and have them quarantine. You don't need to wait for a health department or for a doctor to say you need to quarantine. You as an employer can require that. As I noted, there are privacy concerns. And so when you see somebody who's tested positive or they have symptoms, you certainly want to protect your other employees, but you only have limited ways that you can do that. Contact tracing is still a challenge, but you want to talk to that employee and hopefully they're going to cooperate and they're going to tell you, well, here's who I came into close contact with over the last 48 hours. Close contact, by the way, is defined as being within 6 feet of another individual for a period of at least 15 minutes. And what the state generally asks is that you put people into one of two categories. There's those that have come into close contact and those that are at the same work site. And there's a higher level of responsibility as it relates to notifying employees that have come into close contact versus those that were generally on the work site. And of course, some of this is discretionary, and you've got to make this call. And it's not a perfect science because it's very difficult to determine exactly who might be at risk. If you've got folks that have come into close contact, those are folks that you might want to take that extra step of not just asking them to self-monitor. First of all, you should tell them you've come into close contact with somebody who's tested positive or somebody that came to work with COVID symptoms. As a result, you should monitor for symptoms. You should go get checked out. Those are things you can say in terms of should. But you could also take it a step further and say, we require that you quarantine. We require that you work from home for the next 14 days, or that you at least stay home for the next 10 days. You can require that they undergo a COVID test and say that we're going to need you to test negative before we can let you back in. You can take those extra steps in the interest of being cautious. With respect to other folks that didn't come into close contact, you just need to provide a general notice, letting them know that you are on a work site where somebody tested positive. We have sent separate notice to those that came into close contact. We don't believe that you have, or we don't have knowledge that you have. But nevertheless, we want you to be aware so that you can take whatever steps you deem necessary and appropriate to monitor for symptoms and work from home or do whatever you need to do so that you feel safe. If you have any questions, let us know. So the level of notice is going to depend on how close the person was to the person that tested positive. But importantly, in all of this, we have to protect the individual's identity. All right, so privacy can also come up with COVID tests, right? As I mentioned, you can require that employees get tested. It's not something that I would recommend doing on a frequent basis or without any belief that the person might have been exposed. So it wouldn't be sort of all right, every Monday morning I need you to go get tested. That could, I would expect that would be considered invasive, and there's a line that we have to, a balancing act that we have to walk there. But if you do have folks that you believe have been exposed, if you have folks that are symptomatic, it's appropriate and allowed for you to ask those employees to go get tested. So one of the other issues of concern as it relates to employees being in the office is workers' compensation. You may recall that earlier in the year, Governor Newsom signed an executive order creating a presumption that if an employee was positive for COVID-19 within 14 days of being in the office, it was presumed to be a workers' compensation claim. That order was in effect for about 60 days, and then it lapsed in July, and then there was nothing for a period of time. Well, we now have a new law. It was signed in September, and it's made retroactive, but it's a little bit different from what the presumption was previously. It's similar in that it does say that if you were in the office and tested positive within 14 days of being in the office, that's presumed to be a workers' compensation claim, but only if there has been an outbreak in the workplace. And an outbreak is defined as if you're a company that has fewer than 100 employees, that at least four employees have tested positive during that same 14-day time frame. Or if you're a company that has more than 100 employees, then it's at least 4% of your workforce that's tested positive. So it's not an automatic presumption. But if there is an outbreak, it is presumed that the employee caught COVID while at work. That doesn't necessarily mean it's determinative, it's conclusive, that determination, but it is presumed. And so then the burden will shift to you as the employer to be able to establish that the employee didn't catch it on the work site. That's difficult to do. Again, this is invisible. We don't know how it spreads, but any sort of evidence that you might have, such as, well, this employee told me that they were attending rallies and protests, and they were traveling, and they've been on an airplane 5 times in the last 3 months. They told me that they were going to this event during the weekend, and they were at indoor events without masks. Those are all things that might be counter evidence to suggest that the employee didn't actually catch COVID in the workplace, but that presumption will be there. The last thing I'll touch on is as it relates to employers making decisions to let employees go, and this really pertains to all employees, not just remote, not just on site. But when you're making a determination to let employees go based on economic factors caused by COVID, keep in mind that all the same rules still apply. The fact that we have a very good reason for needing to let employees go doesn't mean that we can pick the employee that we've been wanting to let go all along because they've just been a thorn in our side, right? If we're picking these employees based on performance factors, that makes sense. But there's always a second layer, right? So it's the primary reason we're letting people go is economic. Okay, well, we've made that decision. We have to let go of 10 people. Now, the next question is, for that second layer, which 10 people? And in doing that, it's still important, just like it always is, to do an adverse impact analysis. Determine what are your company's demographics in terms of age, race, sex, and how is that going to shift once we make the decision to let these 10 people go? Is it going to be wildly different so that it looks like we're really only picking on one particular sex, one particular age group, one particular race? And you want to make sure those things are balanced. And if they're not balanced, it may be that that's for legitimate reasons, but you're going to want to just probe a little bit further and say, all right, it's not balanced, but there's a good reason for it. And it's a documented good reason. It's not just this person has performance issues, but we've got the documents to back it up, right? We can show that we talked to this employee, we gave them a verbal warning, we gave them a written warning, we put them on a PIP. Here are some emails that demonstrate the conversations we've had with them about their performance deficiencies. Here's showing that they haven't improved over a period of time, and that justifies our decision. Even though it may not look great in terms of the optics, we're still going to proceed. So all of that is still super important to do, and we don't want to lose sight of that and simply say, hey, you know, we've got a great opportunity here because of COVID. Let's get rid of that person that we wanted to let go of for a while, right? Because there's a reason you haven't let go of them so far. And again, it's very easy for an employee to jump to conclusions because I can tell you, most employees do not think that they are slow, dumb, or lazy. They think they're great employees. They think they perform well, and they think that when they're being judged based on their performance, that it's unfair. So if you're going to be making decisions on that basis, which is typically the reason why you select people, it's normally not, this is really unfortunate, we really don't want to have to let you go, but we got to let somebody go. So we made a determination based on head count. We've got too many people in this particular group. Those are all great. Those are great factors if you can do it, and they're less controversial. But more often than not, you're going to pick your low performers first. So if you're going to do that, it's super important that you're able to demonstrate that they were low performers and that you can actually defend in a court of law, if they challenge you, that that was the reason and the only reason why they were selected. So that's all I have. We have about 7 minutes left. I'm happy to take questions if there's any in the queue.
Boy, do we have questions. They started pouring in as soon as the return to work scenarios came out and the testing of employees. So our first one is a company that has a voluntary testing, COVID testing once a week, and they had a false positive recently. They broadcast, when they first got the positive, they broadcast a general notice of the result to all of their employees, and it really stressed a couple of employees out, and they were very vocal when those employees were, when the false positive was allowed to come back to work. Would you recommend communicating any corrective notification to the employees about the false positive?
You know, it sounds like something I would need to ask a couple more questions on, unfortunately, and I don't know if we have the ability to do that.
Got it.
right now. But it seems to me that, well, my first question is, how did we learn that it was a false positive, and
Right.
what did we communicate to the employees about it thereafter?
Right.
I understand. I mean, if somebody tested positive, that's going to cause employees concern if that person was allowed back.
Right.
I have questions about how did they even know that that person was allowed back,
Mm-hmm.
right? It sounds like, at least my assumption is that they would not have known that unless that person's identity was disclosed. But then again, maybe the employee self-disclosed.
Well, I think,
Um,
I think it was the employees themselves. It says the two employees who were originally asked to quarantine were stressed out and were vocal when cleared to return. So it just
got it.
stressful situation.
Yeah, no, and I get it, and it's not easy, right? I mean, this is a science, but at the same time, it's not a perfect science. And
Mhm.
so, employers, there's been a lot of guidance from the CDC that says don't require employees to test negative before you return them to work. I hear that, and I say, yeah, but you got to be kidding me. They're saying, well, just wait until 48 hours after they are no longer symptomatic, and then they're safe.
Mhm.
Well, that sounds like a gamble. That feels like a gamble. So I'm okay with employers requiring employees to get a negative test, even though
Mhm.
that's not what the CDC suggests.
Mhm.
It's not prohibited. And so, in this situation here, if an employee's got a false positive, well, let's make sure it was a false positive. Make
Mhm.
sure you get tested again. And how do we know that next time wasn't a false negative? So,
Right. How can we
it's not a great
discern
situation.
between the false anything, right?
That's right. That's right. Without taking, 3, 5 tests. And how many times are you gonna require the employee to do that? And I do think that at some point there, it does become a medical exam if the employer is imposing that sort of restriction. Probably the safer thing to do there is not to have the employee tested numerous times and just say, look, in an abundance of caution for our other employees, even though we believe this may be false, we don't know. Just stay home for these next 10 days. We'll pay you. Right? I mean, that's certainly an option to sort of alleviate those concerns. It's going to cost you a little bit of money, but it's going to give you peace of mind.
Okay. And are employers able to have staff fill out a daily form asking how they're feeling or if they have signs or symptoms, or are they just limited to taking temperatures?
It's a good question. You can have a questionnaire. It's got to be a fairly high-level questionnaire, and I wouldn't leave it open-ended. It would, what you should be asking is questions that are consistent with COVID symptoms, right? So I wouldn't just say, how are you feeling? It's, do you have a sore throat? Do you have a fever? Right? It's the typical symptoms that we associate with COVID. If you're asking those questions and it's a yes or no, I prefer that far better than an open-ended question. I think an open-ended question could be problematic because really we're not entitled to know anything unless we're asking specifically if the person has symptoms that are consistent with having COVID.
Okay. And more than 2 companies expressed the feeling that the reason they're not feeling safe to reopen is because either they themselves or other coworkers don't trust the coworkers to keep each other safe from exposure. What do you recommend in those scenarios?
I think it's a judgment call on the part of the company. This has a lot to do with culture far more than it does the law. I noted what the law says. If you've got a safe enough environment based on you disinfecting and keeping social distancing protocols and requiring masking and all that, you're allowed to have people come back. You are not responsible for the individual conduct of your employees when they're not in the workplace. So then the question comes down to, okay, I feel like we've got a safe work environment, but our employees are still very uncomfortable. So what do? Do I require them to come back? Which might create all sorts of ill feelings towards the company and resentment, especially if somebody, God forbid, does catch COVID. Or do we accommodate them and say, look, here's what we're going to do. We're going to allow people to come back if they feel comfortable doing that. We encourage people to do it. But we're not going to require it, right? We're going to have a hybrid approach. Or how about we have some people in on this date, some people in on that date? I think they got to get creative. But that really is more of a cultural issue, which, I do a lot of that type of work with clients as well and walk them through what their options are. But that's the way I view it, is that's really you trying to keep your employees happy, which is absolutely what you want to be doing. I recommend that. It's not just about complying with the law. It's about making sure that your employees are comfortable, because this is a long-term relationship, presumably, and hopefully, and you've got, an ongoing business. So whether it's this employee or the employee that you hire tomorrow, you want to make sure that people are always feeling comfortable on the work site.
Great point, Sarju. And we are coming up on the top of the hour here. We do have a few more questions left. I think it might be a good use of time just to get through the questions. If you're able to stay on for a couple more minutes, if you're not able to stay on, we are recording this session so we can send it out. When you have an employee that has a known compromised immune system for whatever reason, and they're not comfortable working at the office, is this the type of situation that would cause additional expenses to be reimbursed? Because they're in a way they are choosing to be at home, but it's because of their health issue.
Yeah, that's good question. So as I understand it, the question is, so we've got an employee who would otherwise be required to work on site, but due to their health concerns and health issues, they're asking for an accommodation, or their doctor is putting them they're making the request for them to stay home. That is a scenario where it really is for the employee's benefit. Even though the employee may not want to, it's for the employee's benefit, and they're asking for it. They're asking for it on behalf, through their doctor. They're accepting their doctor's recommendation. Put it that way. Their doctor can't make decisions for them. They can't make decisions for the company, but the doctor's making this recommendation. The employee is choosing to follow their doctor's recommendation or would like to. And for that reason, if we're providing that accommodation, that is an accommodation. Right? It's not a requirement. We as the employer are not saying you're not allowed to come in. We as the employer are saying you're asking not to come in based on your medical situation. So I would agree that that's a situation where the company would not need to reimburse. But I would still recommend that the employer provide the employee with the tools, with the computer, the basic equipment. Provide them with a phone, provide them with a computer, provide them with a printer if necessary. Give them the tools so that they can work remotely.
Okay. And if we require an employee to stay home and they're not able to work from home, they just have a type of position that it's just not a work from home position, but we require them to stay home, are we required to pay them?
You are not. You are not required to pay them. Obviously, whatever decision you make in that regard is going to create some precedent for other employees. It's a tricky one though. And, when employers call me and say, well, this person just told me that they were traveling, and so we don't want them in the office. So we're going to have them at home, but we're not going to pay them. Well, guess what's going to happen? Your other employees that travel just aren't going to tell you that they're traveling. So you're still subject to those same risks, except that employees aren't being forthcoming because you're not incentivizing them to be forthcoming. And that also creates the additional risk that the employees that are not being paid and they're forced to work from home are going to say, well, that employee traveled and you let them come back. And then it's on us to have to say, well, we weren't aware, right? And then there's a question, were you aware? Were you not? Should you have been aware? So I think, it's one of those things that again, it's not required that you pay employees when they're required to be at home and off of work. But it's something that you should consider doing just to maintain good employee relations.
Coming back to culture, which you spoke about so passionately a few minutes ago. 3 more questions. Is there still an 80-hour maximum for CARES pay?
Yes.
Okay.
It's the same 80 hours as before. Correct.
Okay.
It does expire December 31st unless it gets extended.
All right. And you had mentioned some things about how to define an outbreak. In a company of 100 employees or more, it was 4 people. If you have an in-home care agency where you might have more than 100 employees, but not all the employees are ever together, how do you define an outbreak in that situation?
Yeah, the 100-hour, that's a good question. The 100 employee requirement is at a particular work site. It's not, you're not counting all the headcount of the company. It's counting people that are all working together at one facility.
Okay. And our last question, if someone is working at home and they get hurt at home, is that a work comp claim?
Potentially, yes. The question is always going to come back to, did they get injured in the course and scope of their work? So, this is another one of those things that under normal circumstances, employers are going to have work from home agreements with their employees. And it's something that I definitely recommend. And I'm seeing more and more clients actually listen to my advice on this recently, and they're asking me to help them draft work from home agreements because we're in this for a while, right? Again, at the beginning, we didn't have time. We just had to send everybody home. But you want to have guidance that, look, we expect you to keep your workplace safe and clean, hazard free. Under normal circumstances, we may even ask you to allow us in to inspect or take a look at your designated work area. And by doing that, we're also saying that, look, that area is your workspace. If you leave that workspace and you go down to fix yourself a sandwich and you trip in the kitchen, that's not going to be work related.
Got it.
But yeah, I mean, there's certainly workers' compensation claims that can arise from people working from home. So it's something that you would want to address in advance.
Good advice. Well, this was certainly an hour packed with tons of information. So thank you very much. And thank you to all our attendees today for attending today's webinar presented by Heffernan. We will send information by email with instructions on how to access a copy of the presentation on our website. And thank you very much, Sharju Naran, for your presentation and your time and expertise today.
My pleasure. Happy to be here. I hope you all found it useful.
Thank you. We hope all of the attendees found today's webinar to be a valuable use of your time, and be sure to join us on January 12th for our remote work policies and considerations webinar. So thank you, everyone, and have a safe day.
Take care, everyone. Bye-bye.